Now, I am going to dictate a legal passage at the rate of 120 words per minute. 5, 4, 3, 2, 1. Let's start. It is the submission of the learned advocate for the petitioner that in the light of the above rule, a deemed approval has been provided for which will result in clear abuse of the entire process of obtaining sanction for putting a building within the panchayat area. It is submitted that a comparison of section 208 of the West Bengal Municipal Act 1993 will clearly show that in the said provision there is no such deemed approval provided for, and such a provision is conspicuously absent in Rule 30 of the impugned rule. Therefore, it is submitted that the rule needs to be struck down. We have heard the learned Advocate General on the above submission. Firstly, in order to succeed in a challenge to a bias of an enactment, the petitioner has to bring his case under two heads, namely either the state or the centre lacks legislative competency to enact such a legislation. Secondly, the petitioner has to show that there has been a violation of the fundamental rights granted in Part 3 of the Constitution of India. Admittedly, it is not the case of the petitioner that the state lacks legislative competency to frame the rule. Therefore, on that ground, the challenge to the impugned rule has to be rejected on the second ground, namely as to whether there is any violation of the fundamental rights granted in the Constitution. There is nothing specific brought on record by the petitioner to show that any of the fundamental rights have been violated or infringed. Therefore, on the second ground, the petitioner has no necessarily failed. Even in such circumstances, the only option left is to uphold the validity of the rule as pointed out by the learned Advocate General on and after coming into the force of the West Bengal Right to Public Services Act 2013. Checks and balances have been put in place wherein a party who provides the service has to show within a stipulated time. The government of West Bengal has issued notification dated 25th November 2020 in exercise of its powers conferred under Section 3 within the 2 of the Public Services Act 2013, in which specific timelines have been prescribed for grant of permission for erection of a new structure or a new building in a panchayat area, and the timeline has also been fixed for the Pradhan to act, and in the event no action, the appellate officer has been provided for, and there is also a reviewing officer. Thus, by reading the provisions of the West Bengal Right to Public Services Act 2013 along with the Rule 30 of the West Bengal Gram Panchayat Administration Rules 2004, the learned advocate appearing for the petitioner would submit that there are illegal constructions put up by encroaching government land or vested land. This is entirely a different issue. The person who is put up construction by encroaching the government property can claim no equities, and the question of any deemed approval can never accrue in favor of a person who was not acted in equity, namely rank trespassers or encroacher. In the light of the above, the prayer as sought for to declare the impugned rule as ultra vires cannot be granted. In the result, the writ petition is dismissed. Stop. Thank you. Jai Hind. Jai Mera Bharat.